My name is Peter Hasland. I'm head of this outfit called the Santa Barbara Coalition for Global Dialogue. We've been in business for about a decade. We've tried to bring to Santa Barbara at least once a year, sometimes twice a year, a program of some global significance. And we are a non-profit, non-partisan group. I mean, we're really non-profit. I mean that as an example of that. The board of directors, who I'll introduce in a minute, we take time on an annual basis to double our salary with absolutely no impact on the budget. And you're free to join us, because one of the requirements is that we come together because it's fun to do. It's fun to come together to think out loud about global issues of significance, and what do we think that the Santa Barbara resident would want to hear about, and who do we get to talk about this issue. Typically we have two speakers, not necessarily on opposing sides, but on at least presenting different points of view. We deliberately do not call this a debate. We call it a dialogue. Today's dialogue is sort of monologue-ish because our second speaker decided he would rather go to East Timor, I don't know why, than come here and have a free lunch. But we have a superb speaker for you in the form and name of David Kay, and I'll introduce him in a minute. We've decided this time to look at the concept of international law. International law is not new. The Dutch philosopher, theologian, essayist Hugo Grotius thought about this. Frankly, he thought about it, about international law, about some way of governing the behavior of states at a time of enormous chaos, enormous savagery in terms of the 30 Years' War. You may know this history. You may not. But he was thinking exclusively in terms of somehow governing the behavior of states at a time when that behavior was particularly phenomenally atrocious. And just imagine, they didn't have the weapons of mass destruction that we have today. So Grotius was way ahead of his time when he thought about some way of deriving from natural law, what he perceived to be natural law, a set of rules by which nations would agree to be governed. The idea of holding individuals responsible or accountable for their behavior did not come at the same time. Somehow individuals were exempt. Somehow if you were misbehaving, you were doing the misbehavior as a consequence of being ordered to do so by your superiors. Now that idea took a major tumble after World War II at the Nuremberg trials, when individuals, you remember Hermann Goering, Joachim von Ribbentrop, and all of the top echelon Nazi leaders were put on trial. And they were essentially told that the defense that my leader, Der Führer, told me to do this just wasn't good enough. You had a higher level of accountability. And the court, an ad hoc court, a court of the moment, made sure that there were penalties to be extracted from people who had behaved very badly during a very long and very costly, in terms of human life, war. The idea then to create a permanent court was to get away from the idea that this was, well, frankly, a court of victors. Those who won the war put those who lost the war on trial. That jaundiced the verdict. It wasn't quite right. What we needed was a permanent court, an international court, an international criminal court. And that came out as a consequence of the Statute of Rome, crafted and finally implemented in 2002. and has been at work ever since, often criticized, and certainly not with universal jurisdiction. One of the countries that has not decided to join is the United States. And our purpose today is to examine, why is that? Why did the United States choose not to join? Are there compelling reasons why it should join? Are there liabilities as well? Does one outweigh the other? And to help us understand that is Dr. David Kaye from UCLA. He has taught international relations, international law. He's taught courses on human rights. He's taught at Georgetown. He's taught at UCLA. So our format will be this less than formal introduction, followed by David, followed by some questions and answers. We'll try to get around to you with a microphone because we're videotaping this, because we want the larger community to share in what we do here. So if you will, help me welcome David Kaye.
Peter, thank you so much for the introduction, and thank you to everyone associated with the Coalition for inviting me here. There's clearly not enough of this kind of dialogue in the country right now, particularly not on the kinds of issues that we'll be talking about today. So I'm really thrilled to be here in a place where, as you said, it'll be a monologue. I had hoped it to be a dialogue with former Ambassador at Large for War Crimes Issues, Pierre Prosper. But I will try to speak in as fair a way as I can about both sides of the issues here. What I want to do is sort of start by setting a scene. And the scene that I want to set up for you is sort of a very hot, steamy scene. But it's not what you think it is. It's a conference room in Rome in the middle of July in 1998. So there are literally thousands of diplomats and lawyers and NGO activists from all over the world who have gathered in Rome in the summer of 1998 after spending essentially 7 years trying to hammer out a statute or a treaty for a permanent international criminal court, a court that would take on the legacy of what Peter was talking about from the Nuremberg Tribunal from 1945, 1946. And they had spent these years hashing out their vision of what international justice would look like. And they gathered in Rome, very hot, and not just in terms of the weather. You had in this room, it was at the Food and Agricultural Organization, you had these thousands of diplomats, but really at the center were a few different parties. There were the activists, like Richard Dicker of Human Rights Watch, who is really one of the singular figures in helping craft the International Criminal Court. You had an American delegation of over 50 lawyers and policymakers and representatives, aides of different members of Congress. So huge delegation. You had delegations from Canada, which were very often in the lead on these kinds of issues in the late 1990s. And the president of this conference, the one who sort of chaired the conference, was a Canadian diplomat named Philippe Kirsch. And throughout this period, these 5 weeks in July, the negotiation got more and more heated over such issues as the role of the Security Council in deciding which cases should go to the International Criminal Court, the question of when national courts should be given priority over an international court, a whole set of issues around whether any particular individuals may be immunized, may be beyond the reach of the court. And it came down to the very end game, July 16th, 1998, and there was no agreement, basically. The United States remained opposed, in part because of different issues that we'll talk about today. And the chair, the Canadian president of the conference, really pushed through in an incredibly skillful way a draft statute of an international criminal court. And by acclamation, the court essentially came into existence after a procedural vote. At the end of this vote, and this is the point where I want us to just think about sort of the intensity of emotion at this time. The entire conference, with the exception essentially of the US delegation, the Chinese delegation, and a few others, there were only 7 countries that voted against this procedural motion that led to the creation of the court. The entire conference rose and did a standing ovation, congratulating themselves for the historic work that they had done. And this went on for over 10 minutes. And during this period, the US delegation, which was sort of sheepishly watching this whole episode, felt that it was really like a taunt, right? That the applause had in a way turned into something that was much more than just congratulating themselves for having reached this moment where 50 years after Nuremberg, there would actually be a permanent international criminal court. And it's at this moment, really, where I want to start the conversation today, which is this feeling that on the one hand, the United States was very isolated in Rome, that the United States, which at least since 1995, when President Clinton expressed his great support for an international criminal court, the United States was really moving in the direction of supporting a permanent ICC. But its vision, the US vision of a permanent court, did not mesh with what the rest of the world was hoping to establish. And that collision of visions, while at the same time both supported this vision of international justice, is really at the heart of the dispute today over what kind of permanent international court we want. What kind of permanent international court raises problems for those on the right? What kind of things that the court isn't doing might raise problems for those on the left? So what I'm going to do today, keeping that vision in mind, is do 4 things. And hopefully I'm going to try to go through these really quickly because I want to leave as much time as possible for Q&A. But first I want to just give a brief overview of the features of the Rome Statute, so we have a little bit of a sense of what it is we're talking about when we're talking about the ICC. I'll then go through what I think are the main points of opposition to the Rome Statute and to the ICC generally, hopefully laying out a little bit the contours of the debate in the United States. I'll then talk a little bit about the trajectory of US policy, so where has US policy been since 1998 through today, and then I'll talk a little bit about where we are today. So if I'm lucky, I'll be done by 12:30, but I might have to sort of Federal Express this in at some point and speak really quickly. Okay, so first thing, what are the features, what are the key features of the Rome Statute? So first of all, it's an international treaty, right? It was adopted at the Rome Conference. When people talk about adoption, they talk about the voting in favor of this treaty in Rome, and afterwards states were invited to sign the treaty. Signature doesn't mean that you're bound by the full treaty yet. You still have to go through a ratification process. So we know in the United States, submitting to the Senate, getting 2/3 support, et cetera, et cetera. All states have some kind of process for that, but this is an international treaty that was sent to states around the world. Today there are 119 states, and when I use states today, I'm talking about nation states. There are 119 states, 119 governments that are party to the Rome Statute, that are members of the ICC. So, first thing to keep in mind about the ICC are the crimes under its jurisdiction. So the crimes include crimes against humanity, war crimes, and acts of genocide. Those are the main crimes under the statute. A year ago in June, the members of the ICC voted to also include the crime of aggression, which is the crime of illegal use of military force, as a sort of another crime under the jurisdiction of the court, but that won't be effective until the very earliest 2017. So we can put aggression to the side and just talk about these sort of key crimes. Basic principles of criminal law apply under the Rome Statute. So that means, for example, that only individuals are subject to the jurisdiction of the court, principles of fair trial, principles of sort of no prosecution for crimes that didn't exist at the time in which the acts took place. Basic criminal law, if there are any criminal law lawyers out here, sort of the process in the ICC and the law of the ICC is really not all that different, at least in terms of the basic criminal law, than what we would experience in either a domestic US court, a state or federal court, or really anywhere around the world. The other thing to keep in mind is that the court came into effect after the 60th state ratified the treaty, and that wasn't until July 2002. And so past crimes, historical crimes, whether we're talking about the Armenian genocide or any kind of crime that you might imagine that happened before 2002, is outside the jurisdiction of the court. So it is very much a contemporary court. It's about crimes that take place more or less today or within the last several years. Okay, so that's sort of the very broad overview of the criminal aspect of the ICC. Secondly, it's international, right? It has all of these states that are parties. It's based in The Hague in the Netherlands, which is in some respects the Center for International Justice. The International Court of Justice is there, which is the court for the United Nations. There are the tribunals for the former Yugoslavia, Special Tribunal for Lebanon, and several others based there as well. The court has no police force, right? It doesn't have an army that it can call upon. So one of its deepest problems is getting the cooperation of states, whether we're talking about arresting individuals or simply collecting information. So it is a court that operates in an environment where, unlike law enforcement in the United States, where you can obtain a subpoena from a judge and then use the full force of the law in order to go get information or to arrest an individual, the ICC doesn't have that. It has to work in an environment where it constantly needs to work for the support of states. In that respect, some might say that it is a bit political, but I see that really as just a reality of the court, that it really needs to work in order to make its work successful. Two other points that I want to make here. One is how the court gets its jurisdiction. So the court can get jurisdiction, that is, it can investigate and prosecute a particular situation and a particular individual in basically three ways. So one way, and the key point here, is that the crime, for at least these next two versions, the alleged crime needs to take place in the territory of a state party, so a state that has already ratified the treaty. So it has to take place in the territory of one of those 119 states, or the crime has to have been committed by a national of one of those states. So that's sort of a basic requirement for two kinds of assertions of jurisdiction. So one is the prosecutor, acting on his own authority, can ask the judges, a chamber of 3 judges, for the authority to move forward with an investigation and a prosecution. And once he, or perhaps the next prosecutor will be a she, once she gets that authorization, she can move forward with the investigation and prosecution. So that's one possibility. The prosecutor gets information from all over the world and decides, I'm going to take on this particular case because it's a state party or a national of a state party. The other way is that a state, another government, can actually refer the case to the ICC. So that any state can do that. It's happened in 3 cases already where a state has basically said, we can't do this ourselves. We'd like the ICC to conduct this investigation and prosecution. But it could also be done in a way where you could imagine one state says, my neighbor committed these bad acts, and I'd like to refer these bad acts to the ICC. So those are 2 ways. The ICC prosecutor takes it on his own initiative, and the second way, a state refers. The third way, the one that may be on your mind over the past several months, or 8-9 months, is when the Security Council actually refers a case to the ICC. So within the Rome Statute, there is the authority for the Security Council to, based on a resolution of the Security Council, so it means a resolution that isn't vetoed by one of its permanent 5 members, the US, the UK, France, China, or Russia, can refer a case to the prosecutor. And that's happened twice, in the case of Darfur and Sudan, and the case of Libya back in February. Finally, just in talking about the structure of the Rome Statute, is the issue of complementarity. So complementarity is kind of a jargony word. All that means is that the ICC is supposed to be a court of last resort. Right? The court is only supposed to step in when national jurisdictions are unable or unwilling to pursue an investigation or prosecution genuinely in their own territory. Right? So we'll get to this in a second because this is one of the major areas where the United States at least expressed some concern. And that was over the question of what are the safeguards on ensuring that the ICC only operates when national jurisdictions don't work. Okay, so that's the overview of the Rome Statute in a very general way. So what are the main points of U.S. opposition? So this would have been the point where Pierre, Prosper, and I would have been in dialogue. So I'm going to try to step into Pierre's framework here a little bit. But generally, I think these are the main areas of U.S. opposition. And I would say, generally speaking, the concern that's been expressed by American politicians, in particular members of Congress, but also people like John Bolton, who you've probably heard, he was the American ambassador to the UN. I mean, their general line is that the ICC, in a way, restricts the freedom of action of the United States. How does it restrict the freedom of action? Well, the United States has a far-flung military presence around the world, is very active in all sorts of operations, whether they are military or they're civil-oriented reconstruction kinds of efforts, or maybe just visiting countries around the world. And the concern is, to the extent that the ICC gets involved in things that the United States is engaged in, it restricts the ability of U.S. military and political leaders to operate. Okay, so that's a general, but I think that's too general for really a specific argument. So what are the really specific arguments that the U.S. government has made or that opponents have made? So one is the role of the Security Council. During that negotiation that I was describing earlier, the real key, despite all the other stuff that you might have heard about the ICC, the real key interest of the United States was making sure that the Security Council would be the gatekeeper for any case that went to the ICC. Now, they more or less stepped off that toward the end because it was clear that just wasn't going to happen, right? We can imagine what the problems would be if you had only the Security Council as the gatekeeper, right? Because in that kind of situation, you would have, first of all, the 5 permanent members of the Security Council who can veto any resolution. There would never be a case against them. Maybe okay, maybe not. But also all of their friends and allies would be probably protected by that. And that would undercut the credibility of a court that is really designed to prosecute individuals regardless of where they're from or regardless of the morality of their original use of force, right? So that would be one problem with it. And what happened in the course of the negotiation was, instead of the Security Council being a gatekeeper, the Security Council has a very limited role. While on the one hand, it can refer cases to the ICC, so cases where essentially the United States agrees, those can be referred to the ICC. In other situations, the Security Council really cannot stop the court very easily from moving ahead. It does have this ability to, and it's within the statute, to defer a case for a period of 1 year. But that's a pretty limited authority of the Security Council. And if you can imagine, how hard it is to get a piece of legislation through Congress. Maybe that's worse. But getting something through the Security Council is pretty tough also. So you can't really rely on having that kind of break on the Security Council. So that's one thing, the role of the Security Council. And what that means is that from the perspective of those who are thinking about U.S. national interests and freedom of action, there's always going to be this concern that the Security Council, that the United States cannot put brakes on any particular action by the ICC. Second, perceived weaknesses on this issue of complementarity. That is the issue of national jurisdictions being the first place to go and the ICC being a last resort. So one is that the standard for identifying when a national jurisdiction is conducting a genuine investigation is whether it is unwilling or unable to pursue an investigation. The standard is very vague. And so I think rightly, and as a former negotiator for the State Department, so I worked for the State Department for 10 years, lawyers at the State Department are lawyers, and they're going to lawyer a document, right? And they're concerned at the time that this was too vague of a standard, and that down the road it could be a very big problem for the United States if they pursued an investigation, but the investigation maybe didn't uncover anything, but maybe the ICC wouldn't see it the same way, that the ICC could still pursue a U.S. national in that kind of situation. The standards were just too vague to be clear about when complementarity worked. The other thing was that there was some concern that, having seen other international courts operate, that some people at both the State Department and in the military and in Congress were concerned that an international body, whether it's a court or a political body like the Human Rights Council, wouldn't really be able to appropriately assess what it is the United States or any other national court was doing in order to investigate and prosecute its own nationals. There was simply a concern that that would never be kind of a fair, rigorous analysis of what was happening nationally. Okay, so that's the second argument against the ICC among those who oppose it in the United States. Another one is this concern that the prosecutor would be unaccountable. And you see this all the time, concerns about an unaccountable prosecutor who didn't have sufficient checks on his or her authority, his or her ability to pursue an investigation or prosecution. There's some fairness to that argument. So the way the ICC is structured, right, there's no overarching political body that's really worth much. It's basically the prosecutor and a panel of judges at the court who can say yes or no to particular investigations. And from the U.S. perspective, I think the argument would be we have no control over who these judges are. We don't know how talented, how competent they are. There have been experiences with fairly untalented judges in the past, and I mean, that's a domestic problem too. But there's a concern, again, it goes back to the freedom of action in the United States and this concern that the prosecutor would be able to pursue any kind of case that he or she wanted without sufficient kind of checks that we might want to see in a domestic environment, and those wouldn't be there. Plus, there was a concern that if you had a prosecutor who was very political or politicized, that the prosecutor, even if the judges said no to him for a particular investigation and did not authorize a particular investigation, there was a concern that simply giving a prosecutor who might have animus toward the United States or its allies a platform would be bad enough as it is. Right? It doesn't really matter if it goes to trial. If you have an actor out there who's out there talking about how bad the United States is in a particular area, that's not something we want to authorize. So that's a third concern. I'm going to skip one and go directly to the last one, and that is the issue of the constitutionality of Americans being tried by an international court. Here I'm going to step out of the debate dialogue style and just say that that's pretty much nonsense, in my view. Now, why is that? So although, if someone has a different view, so the argument is essentially that under the Constitution, and this is where I think it would have been nice for Pierre Prosper to be here to really articulate this concern, but the argument is essentially that under the U.S. Constitution and separation of powers kinds of principles, that only particular branches of government are able to determine whether someone can or cannot be prosecuted, right? So it's the executive branch's discretion to determine who should be prosecuted. It's the judiciary's responsibility to determine guilt or innocence, and it's the legislature's responsibility to identify the crimes that are out there. And if you create an international court, you take it out of the sovereign hands of the United States to do those things, whether it is to define the crimes, to decide who should be prosecuted, to decide guilt or innocence. Now, at one level, that clearly makes sense. The problem is that Americans are tried by both international, not so much by international courts, but they're tried for crimes around the world all of the time. So whether we're talking about universal jurisdiction, where we're talking about a crime that is subject to prosecution and investigation by any court around the world, these are things like grave breaches of the Geneva Conventions or torture or the worst things that you can imagine. The United States has already agreed in the 1940s and 1950s to that kind of process. And that's sort of allowing others to prosecute your own nationals. And the other thing is, if you, as an American national, violate any nation's crime, any nation's laws, you may be subject to the criminal jurisdiction of that other country. So I don't see, maybe I'm overstating it to say that the constitutionality argument is nonsense. But it doesn't make a lot of sense when you think about it in the context of what the United States has done historically, what it's done over the past 60 years, and sort of the way in which the world has become interdependent, and that states prosecute other states' nationals all of the time, and that international law has, particularly in the context of human rights law, but also in international justice, has really expanded its reach to govern behavior by individuals around the world. Okay, so I'm going to try to wrap up in the next 5 minutes and do the very quick and dirty run trajectory of US policy. So obviously after the Rome Conference, there was great disappointment in the United States. President Clinton had been supportive. The military had been negative, although not as negative, I think, as some people might imagine. And there was a huge push against the court by Jesse Helms, who in the late 90s, I'm sure you remember his name, the late Jesse Helms, he was the chairperson of the Senate Foreign Relations Committee and never saw an international law that he liked, right? So he was deeply opposed to this and raised all of these points of opposition that I just mentioned. But the US, the Clinton administration at least, was so disappointed with the outcome and had so hoped that it could have created a court that would have been to Jesse Helms' liking, basically, because you needed the Congress to support it if you were ever going to ratify it, of course, that the US negotiators stayed involved in the process after the Rome Statute was even adopted and tried to get there to be amendments to the Rome Statute. There was a whole thing called a preparatory conference in which the states that were involved at the Rome Conference were involved in looking at defining the crimes under the statute, looking at the rules of procedure, and the US delegation tried very hard to try to get there to be rules and definitions adopted that might soften the blow of the statute itself. They were unsuccessful at doing that, but nonetheless, the Clinton administration, on the last day possible, because the Rome Statute is only open for signature. This is typical with any treaty. It's open for signature for a certain period of time, and then a state can be a signatory to it. And the date on which that ended was December 31st, 2000. So remember, Bush v. Gore had already been decided, so we knew the next president was going to be George W. Bush. President Clinton authorized the United States to sign the Rome Statute. So the United States, well, it's not all of us, the ambassador at large for war crimes issues, David Sheffer, went to New York to the UN where the statute was held, and he signed the statute. The Bush administration came in and made that a pretty big issue. They said, there's no way that we're ever going to support this thing called the ICC. John Bolton led this effort, and the first thing that they wanted to do was to unsign the statute. Now, there weren't really serious obligations on a state that had only signed it, but it presented a symbol of where the United States was going to go with respect to the ICC. You can't just use whiteout to get rid of a signature. I know my kids have no idea what whiteout is, by the way. It still amazes me. But so you can't do that. But what it really did mean was that the Bush administration said to the international community, we're not going to take the signature the step further and send it to the Senate for ratification. We're just not going to do that. But this was sort of the tip of the iceberg, because the Bush administration in its first term did a number of other things, and they were egged on by congressional hostility. So Congress passed and the president enacted the American Service Members Protection Act, the ASPA, which provided all sorts of sanctions on governments that deigned to support the ICC, and including cutting off U.S. military funding or foreign assistance to countries that joined the ICC, although there were waivers built into that. But this was congressionally driven, but Bush administration supported. The Bush administration pursued what were called Article 98 agreements. These are basically agreements in which the United States sought to get agreements with other states to get them to immunize U.S. nationals who might be subject to the jurisdiction of the court. So in other words, these states would say to the United States, we're not going to send any of your nationals to The Hague to be prosecuted. And we concluded dozens of these agreements with states, although nobody in Europe, I think with the exception of Romania, would agree to one of these with the United States. There was strong antipathy toward the ICC in UN resolutions. So even in peacekeeping missions, the United States insisted that there be an immunization of US forces from ICC jurisdiction, and it would hold up different UN resolutions for that reason. And then the United States simply did not participate in any ICC meetings. And observer states can go just to observe, but the United States really put an iron curtain sort of between itself and the ICC. That changed over time. So in 2004, 2005, Darfur became a very public issue in the United States, and Colin Powell in the fall of 2004 said, it's a genocide. And if you're going to say it's a genocide, your next question is going to be, how are you going to hold these people accountable for a genocide? And so the United States was sort of put into a corner, and even though it was seeking other ways to create a tribunal for what was happening in Darfur, there was strong pressure within the ICC community to look to the ICC, because one of the reasons you create an ICC is you don't have to have the costs every time of starting up a new tribunal. Here you had a tribunal, you could refer to it directly. And so at the end of March in 2005, the United States abstained from a resolution at the Security Council that referred the situation in Sudan and Darfur to the ICC prosecutor. And that, I think, is a moment where I can start to conclude by saying that that was when really the US ICC policy started to move in a way that is supportive of the ICC, of its goals, but clearly avoiding the question of ratification. It's not on the table for the Obama administration, that's for sure. Certainly not in this term. I'm just going to stop there. The Obama administration has basically taken it a step further. The Obama administration participates in ICC meetings. It's very involved, for example, in this conference last year that adopted a resolution regarding aggression. The United States was very much a part of that negotiation, and I think feels pretty comfortable about that outcome. It's expressed a lot of political support. It voted in favor of the referral of Libya to the ICC. And just within the last month, the United States has sent military advisors to Uganda and its neighboring countries in order to deal with the issue of the Lord's Resistance Army, which is its key leaders have been subject to arrest warrants of the ICC. So the United States is definitely moving in that positive direction. I'll conclude by saying just a few quick things about the ICC today. So the ICC has 7 cases, 7 situations right now. So you can have dozens of cases for each situation, but the 7 situations are the Democratic Republic of Congo, Central African Republic, and Kenya. And those are cases that are situations that actually will move to trials or are in pending trials as we speak. And then the cases where there are situations but there's nobody who's been apprehended are Uganda, Sudan for Darfur, Libya, and Cote d'Ivoire, the Ivory Coast. Criticisms of the court: it's got a slow process, it's expensive, oftentimes it can be politicized, and we can talk about the case, for example, of Palestine and the ICC if people are interested in that. But generally speaking, I think that the US move that's been much more supportive is indicative of a sense that the ICC, whether we agree with all the particulars on the legal aspects or whether we agree with its role in the international affairs more generally, is in a sense a power today that is a real player in international relations. More than any other institution around, it makes sure that accountability for the worst crimes known to humanity are on the table, along with the issues of conflict resolution and moving forward. That it is hard to imagine moving forward in many conflicts today in the absence of having justice and accountability. So however one sees the court, I think it's here to stay. And I'll conclude there and hope that we can talk about some of the pros and cons of the court. So thank you.
Larry Martinez, Cal State Long Beach. At first, I enjoyed your talk very much, and it's going to inform my next lecture in my international law class about the background to the ICC and its ratification and so forth, or non-ratification. My question pertains to, for instance, the indictment of a incumbent chief executive, so Mr. Bashir of Sudan. And Mr. Sudan has left the territory on multiple occasions, going to other countries. Is there an obligation under the ICC or any other aspect of international law that could require states to place that person who finds themselves on their territory into a state of arrest or some sort of state of containment under the ICC?
Right. Thank you. I wish I knew you were going to be here. We could have carpooled.
Yeah, I'm driving back.
It'll be a convoy now. So that's a really great question. So under the Rome Statute, so I mentioned these different principles of criminal law. This is actually one of those areas that's different from domestic law. You know, we're very common to, we're very used to hearing about sovereign immunity, right? The immunity of either the head of state or the government to suit or to prosecution. The Rome Statute says you can't have a claim of head of state immunity. So Bashir can't claim that, well, I'm the president, so you can't arrest me. And that works in the context of his travel to different states that are party to the Rome Statute. So if Bashir goes to Kenya, or if he goes to Chad, those are both states that are party to the Rome Statute, they're ICC members. Those states have an obligation under the Rome Statute to arrest him and transfer him to The Hague. Right? So forget about head of state immunity in that situation. There's an actual obligation to send someone. And that's really, I think, the way people think of the symbolic value of the court, but also has a real value too. That doesn't work for non-states. So if Bashir were to come to the United States, for example, he's not going to come to the United States because my guess is actually the United States, as a matter of principle, would arrest him and send him to The Hague. I think that there's a decent chance that would happen. But the United States is under no legal obligation to send him to The Hague. So it creates this kind of bifurcated world where you have some states who are obligated to uphold this principle and others that are not.
Yes?
Alison Brisk, I'm a UCSB professor, and so I couldn't carpool with you. But I teach international human rights, but I'm a political scientist. So what I'm testing here is sort of the politics behind all of the legal mechanisms and decisions that have been made, and have discussed the ICC a lot in my classes and some of my work. So my own inclination and my own interpretation that I want to test with you is that because of complementarity and because we do participate in a whole web of other transnational legal mechanisms, from the Alien Torts Act to all sorts of bilateral universal jurisdiction mechanisms and extraterritorial jurisdiction for, you know, sex offenders and all kinds of things, right? It's not that we won't do that. We won't do the ICC not because of service members either, because again, there are many other ways they would be accountable. Really, it's that we don't want command responsibility for executive branch officials, such as the attempts at putting Bush on trial in various European domains, the case against the CIA in Italy, and that's the real barrier to U.S. full-fledged participation in the ICC. Do you agree with that interpretation? And if that's true, how can we ever get around it?
I think it's right. I would say two things. So one is, I think you might be understating the power of the argument about service members being protected. My sense of America today is that service members occupy a particular place both in our political environment, but also in sort of our notion of who we are. So I think that that's actually a very strong part of the argument against the ICC. But that isn't to say that the political leadership isn't an issue also. And I think that may go to that overarching question of freedom of action, right? So, I mean, in the context of any of the areas where the United States is engaged today, where you might have ICC engagement, I think that policymakers are thinking twice about what they should be doing. They made a very strong effort in the Libya context, for example, to immunize themselves. So in the Libya resolution, that is the Security Council resolution that referred the Libya situation to the ICC, they included a provision that says that only Libyan nationals essentially will be subject to this resolution. Right? Nobody outside, no non-party state, no non-ICC members. So I think that that probably goes to your argument that it's about the national political leadership. But I think those kind of dovetail with the service member protection as well. I think those things aren't mutually exclusive. Right? Okay. But I think your account generally of the U.S. government's overall commitment to accountability is exactly right, which to me makes it a little bit more of a puzzle as to why we've been so opposed to the ICC more generally.
I want to ask you if the issue of whether or not we've signed has implications for what our duties are if we've signed, as opposed to whether Bush could unsign the treaty. That's first. And the second is, would you say something about the issue of the definition of aggression, some of the issues there, and where that stands? The definition, not exactly when it enters into force.
Sure.
Okay, thank you.
Okay. So the first question has to do with signing, and I guess the implications of signing and unsigning, right? So generally speaking, under international law, if you sign a treaty, right, it doesn't mean that you're a party of the treaty. It doesn't mean that you're obligated to all of the different provisions of the treaty. What you are obligated to by signing is to uphold the object and purpose of the treaty. So if the United States is a signatory to the ICC, the argument would be that the United States can't adopt an extremely hostile attitude to the ICC or try to get other states not to join it, because that would be inconsistent with the object and purpose of the treaty. So this idea of unsigning the treaty early in the Bush administration had a very particular kind of legalistic reason behind it, which is we want to be hostile to the ICC. And if we want to be hostile to the ICC, we can't be a signatory because we'll be violating the spirit of the thing. So that's where that came into play. When the Obama administration came in, it didn't announce we are re-signing the statute. It's simply performed in a way that's more supportive of the ICC. So that's I hope that answers sort of the unsigning, signing kind of issue. On the aggression issue, okay, so aggression is a very long and complicated area, and so I'll try to boil down some of the key issues. So basically, the question, well, step back a bit. So the United Nations Charter forbids the use of force, generally speaking. Article 2.4 of the Charter says states cannot use force or the threat of force in their international relations. And then there are two exceptions to it. One exception is if the Security Council authorizes use of force. So the Iraqi invasion of Kuwait in 1990, Security Council authorizes force. The United States and a coalition oust him. That's okay because it's been authorized by the Security Council. The other is use of force in self-defense, which is called an inherent right of self-defense, which can be collective, a group of states, or just individual self-defense. The argument of aggression is that if your use of force doesn't fall into one of those two categories, what amounts to aggression, that the senior official can be, sort of either the military leader or a political leader can be held accountable for that use of force. And that's where the debate was mainly. So there were two kinds of debates over the definition of aggression. So one was, what uses of force amount to aggression? Would so-called humanitarian intervention amount to an aggression? It's not self-defense necessarily. it's not necessarily authorized by the Security Council, it would seem to be barred by that Article 2.4 prohibition. So, I mean, that's just sort of the most obvious kind of problem you might have. But, what else might count as an illegal use of force for which there should be accountability? The other issue is the one actually related to the one I was talking about earlier, which is what is the role of the Security Council? So is the ICC able to simply say, here we found an aggression? Well, if they are, that could be inconsistent with the Security Council's responsibility under the UN Charter, which gives to the Security Council the authority, or the responsibility, actually, to maintain international peace and security and to determine breaches of the peace or acts of aggression. So it seems that, and this was the problem, is the ICC kind of trumping the Security Council's role in this area of aggression. And that's where the debate was. So you can imagine what the United States thought, right? The United States, and this is bipartisan, the United States thought, well, I mean bipartisan in the Washington sense. It's very different from the range of opinions that may be out there. But it's, I mean, the bipartisan view was the Security Council needs to really be the gatekeeper in this kind of situation. And so what happened was, in this negotiation last late spring, the negotiation was really about how do you find ways to make sure that even if the Security Council isn't making that determination, to really make it so that it's really hard for the ICC to determine a situation of aggression. So we ended up, and I think it's an incredibly convoluted agreement that they reached, but we ended up in a situation where I think the United States is okay with it because there's really no chance there's going to be a prosecution of a U.S. national or the U.S. military or whatnot for an act of aggression. It's going to be a very hot topic in 6 years, I think.
Okay.
Did they decide on the definition of aggression?
Yeah, so they decided on the definition, but like I was saying, I mean, they identify a bunch of examples of what might be an act of aggression. It leaves open this question of where humanitarian intervention stands.
My question is sort of a two-part question, and I'll try to make it as clear as possible. I'm not sure if I'll be successful in that, but I'll try. So my question is, you mentioned the Security Council, the UN Security Council, and that there's 5 permanent members there that essentially wanted to be like the gatekeepers of whatever crimes are referred to the ICC. My question is, given the history of the world in terms of balance of power, where you have Western powers sort of, I'm from Zimbabwe, by the way, so my question might be a bias there, where you have Western powers sort of colonizing or controlling third world countries, especially African countries. And when you look at the core of that Security Council, how, especially with the US, how then are the underdogs represented? How is that balance of power? How do they end up being able to self-determine when you have such structures within the Security Council, first of all, and even with the ICC? My question is also, the second part of the question, I'll try and link it all together. In terms of the crimes that the ICC sort of tries, and which I think is where you have the US hedging and things like that, what about economic crimes? Because you look at, for example, Western powers endorsing authoritarian governments that end up committing these human rights violations for reasons best known to them, maybe to secure resources or what have you. When you look at Egypt, the Suez Canal, you look at Libya, oil and things like that. How then does an organization as the ICC, the Security Council, how do you sort of balance all that? Well, what's the, I guess, the solution when you have superpowers like the US hedging and clearly going out of their way to represent their own interests? How then do underdogs self-determine and rise up?
Right. I mean, I think it's a great set of questions, and you could write a thesis or a dissertation on it, so you should think about that. So on the first part of that, which I sort of take as, you have basically the 5 permanent members of the Security Council. You have kind of an old world, like superpower structure, and then you have sort of ex-colonial powers that have really been the target. All of the 7 situations of the ICC right now are African, right? So that's a problem, and it really undermines. It has served to undermine the credibility of the court in some quarters, right? I mean, that's clearly an issue. So, putting that to one side, one way to deal with that is for the states in the region to really try to address accountability on their own as well. Right? I mean, that's clearly one way in which you can imagine. So Kenya is a perfect example. Kenya has a modern, very effective judiciary, and the ICC has been engaged there. And Kenya hasn't been pursuing accountability for its own military and political leaders following the election violence in 2007. So I think it's sort of a two-way street in a certain respect. But I think you're really right. So I think that in terms of this disparity of power and how it ends up working in one region and not in other regions. And I think that the one way that hopefully the court can fix that is, first of all, they have an election for a new prosecutor next month. One of the candidates is a Gambian lawyer, a woman named Fatou Bensouda, who's very good. I think there's a good chance that she'll be elected. And I think having a leader who is African, who comes from that environment, who has a foot both in sort of the domestic law in her own country in Africa and international justice, I think could be a really big shock to the system in a way. I mean, it could be very important both for Africa and for the Security Council. But I think in general, I mean, if you want to take sort of a higher altitude view of the Security Council's role, I think it's very negative right now. I think that it isn't fostering a sense that all states should be supportive of the ICC, that it's not just a court for Africa. I think it's been actually kind of problematic. So I think a big part of your question is definitely true, sort of the premise of it. On the question of economic crimes, so economic crimes are simply not under the jurisdiction of the court. But there are different places where people subject to, people who may be committing economic-oriented crimes may be prosecuted. So just to give an example, there's been an effort by the Open Society Institute's Justice Initiative, OSJI, to define the question, or to define the crime of corporate pillage. So to give you an example of what this means, pillage is a war crime, right? Pillage it's one of the oldest war crimes, right, that we can imagine. So it's clearly a war crime. The question is, in particular in the eastern DRC, after the Yugoslavia Tribunal was set up in 1993, a year later, in the wake of, and it's always in the wake of, the genocide in Rwanda, the Security Council created the Rwanda Tribunal. So that's just so everyone knows what the questioner was asking. So they operate in really difficult environments. They're outside of the country. It's very hard to get witnesses. So there are certain reasons why they're slower, and so I think that we need to cut them some slack. The ICTR, the Rwanda Tribunal, is actually heading to its twilight phase right now. Both the Rwanda and the Yugoslavia Tribunal are scheduled to shut down at least the trial phase of their work within the next couple of years. So if they don't finish what they're doing, they're going to be out of luck. So, I don't think there's much that I can offer in the way of speeding up those trials, except to say one thing that the Security Council has not done very well, and mostly hasn't done at all, is to really encourage states to cooperate with these tribunals. It's done none of that for the ICC, and particularly in those cases where there are referrals, for Libya and Darfur, I think the Security Council, which is responsible for these, should have also said it is an obligation of every state to either arrest, so we're talking about the arrest issue, right, head of state immunity, extend the obligation to arrest to every state in the world. Why couldn't they have done that? They referred the case also. So there are certain things that they could have done to make it easier. I think one of the slowness concerns has to do with the visual of not, it's not just the visual, the reality of not having these most senior accused perpetrators of actually being arrested and being in the dock. So it looks like it's a very slow process, but in fact, there's not much that the tribunals can do when they don't have those indictees in the dock. So, I mean, to me, that's the bigger problem. So the Rwanda tribunal is a perfect example of that, where they did all the work that they had to do in terms of investigating and seeking arrest warrants and all that, and they couldn't get the cooperation from governments to make sure that the process would move forward.
Do you see any prospect for the internal domestic politics to change in terms of ratification by the Senate? Or do you think that it's the serviceman issue that you talked about is so potent electorally that, and so easily turned, that ratification is effectively off the table for quite some time? Second question deals with Yemen. And the question is, as part of the GCC negotiations, there's the offer of immunity for the president for crimes that are committed during the last 9 months, 10 months. Can an international agreement like the GCC actually waive the culpability of the president in terms of actions that have taken place within the last year?
So I'll start with the first question on the U.S. politics side. I think my answer is probably not necessarily any better than anybody who reads the New York Times or follows some of these issues. I mean, my sense is that it's not on the table. Ratification is clearly not on the table for the next year. I mean, there's no way the Obama administration would put it into play in an election year, particularly a tough election year. Afterwards, who knows? It depends on who wins in one sense. But I also think that the ICC itself needs a couple of very high-profile victories. I mean, it needs to be seen as not just a paper tiger. Right now, it's not seen necessarily as a paper tiger, but it's seen as being even among its supporters, I think, as being an important institution that hasn't yet reached its full potential. And so once it gets to the stage where it has Bashir in the dock, or it has, it could be Saif al-Gaddafi, Muammar Gaddafi's son. I mean, if it gets one of those people in the dock and it prosecutes the person and is seen to do sort of a fair trial and does a great job, I think the dynamics might change. But before that happens, at least over the next year, I don't see anything changing. I do think that some of the arguments, the points that I raised before in opposition, are kind of tired old arguments at this point. I'm sorry to sort of disrespect my own talk, but I think that those issues aren't as salient to most people, even on the right these days. I think there are some kind of bigger issues. I mean, one of the biggest issues that I would be concerned about, just from the political side, is whether there's an investigation and prosecution related to Palestine and Israel. If that happens, my answer is forget about it. The U.S. won't even cooperate with the court. I mean, we saw how there's been cutoff of aid to UNESCO simply for the Palestinians having a state recognized there. So that's a big, big open question, I think, moving forward. So on the Yemen issue, Gulf Cooperation Council, immunizes. That shouldn't have any impact on whether the president of Yemen is immune or not immune internationally. So if, let's say that the ICC got a referral from the Security Council over Yemen, that referral would, depending on what the resolution actually said, would likely trump whatever the GCC says. So regional, sub-regional, and state determinations about immunity can't trump what the Security Council says. And if it's a member state of the ICC, it can't trump what the ICC's obligations are. So imagine that Yemen was a party to the Rome Statute. In that case, they could say our president is immune, but that's irrelevant to the ICC, because at the international level, Yemen would have been saying we are obligated to these principles.
If they're not a signatory, what would be the situation?
Right. So that's why I was suggesting that it depends on what the Security Council would do if there were a referral. At this point, one could imagine Saleh being subject to universal jurisdiction. So he could end up, let's say he ends up in Belgium, or Germany, where there's fairly rigorous universal jurisdiction, or let's say he ends up in Spain, and this Judge Baltasar Garzón, who's no longer a judge there, but that's a long story, if he clearly stepped on the wrong toes at some point. In fact, what he said was, I'm sorry, this is a diversion, but he said he was going to investigate the Spanish Civil War, and soon after that he lost his job. So, but this is the guy who started the investigations of Pinochet, for example, very famous and important magistrate judge in Spain. Anyway, if Saleh were to end up in that kind of jurisdiction, there would be no reason why, I mean, assuming that they could say, for example, hold him accountable for torture of opposition in Yemen, there's no reason why they couldn't move forward, and the GCC statement and Yemeni domestic law would be irrelevant.
How does, because you said that before, that there are ways in which the ICC can get a case, but if, say, a government or a nation is capable of prosecuting the criminals, but they refuse to, does that mean that those criminals are unable to be prosecuted and looked further by the ICC, or it is in that case the ICC has the power to intervene in those situations? Like, do they have jurisdiction?
Right. So, so first taking the Africa question, I actually don't think it's that there's I don't think that the ICC has these 7 cases in Africa because the ICC is anti-Africa or because the states in the region are weak. I think we do have to be honest and say that there's some horrific violence that happened in these countries. Right? We're talking about the Democratic Republic of Congo, which is, you know, one of the worst scenes of really brutal violence in the world since World War II. We're talking about Uganda, where the Lord's Resistance Army killed tens of thousands of people in the north. So, I mean, we're not talking about reaching out to places where there's no basis for an investigation or prosecution. And across the board, I think there are strong reasons on the merits for pursuing those kinds of investigations. I think that that the perception of an Africa focus could have been handled differently. I think that not all of those cases necessarily need to have been investigated. I think that, it's the discretion of the prosecutor to choose them. So, I don't want to dispute all of his choices, but there are other places around the world where the prosecutor, I think, had very strong reasons for pursuing investigations and didn't do so. So Colombia is the best example of that, where Colombia, which is a party to the Rome Statutes, it's a member of the ICC, it had a terrible civil war that went beyond 2002, so there would have been jurisdiction. The Colombian government is really not pursuing accountability for the key figures involved in violence on either the government, the paramilitary, or the insurgent side. So I think that would have helped to do that, and I don't think it would have been political. I think it would have been justified. So I don't see those as political choices to go into Africa. And the other thing is that 3 of the states in Africa that are under ICC jurisdiction right now actually referred their cases to the ICC. Uganda, DRC, and Central African Republic, nobody's picking on them. They actually sent their cases to the ICC. So I don't think it's a question of kind of political weakness. There may be a question of sort of state and institutional weakness that makes it easier for the court to say, we need to pursue this case because there's no chance of there being accountability in that country. The second question had to do with complementarity and the issue of are there situations, right, where say a state is totally able to pursue it but it's unwilling. So the standard is unable or unwilling, actually. So if a country is totally able to pursue accountability for its own nationals, then you look to the question of whether they're simply unwilling to do it, or they're providing their investigations are really pretextual or something like that. So you need to look to both of those things. So in the case of Colombia, as a great example, clearly able to do it, clearly unwilling to do it, it could be under the jurisdiction of the court. And it's still possible that it'll go that direction. The ICC has been investigating for some time, sort of a preliminary investigation. But whether it'll go the next step, I think it'll be up to the next prosecutor to determine. And the other, one of the problems here is that you've got 7 cases before the ICC. This is just another kind of thing just for the reality of the situation. It's not like the ICC is thousands of lawyers spanning the globe. You know, it's really a very small institution at the end of the day. You know, it has hundreds of staffers, not thousands of staffers. It has, you know, dozens of lawyers and investigators, not, you know, hundreds of them. So its capacity to pursue, this is actually a real concern of mine, is that as it becomes more, as time goes on, there will be more and more cases that demand ICC justice, but ICC simply won't have the capacity because it's already got 7 cases, and it's sort of hard to see how it can do a really good job on any other cases. I had a prosecutor at the Yugoslavia Tribunal once told me that what you have to imagine about these prosecutions is, like, imagine taking the biggest case imaginable and sending it to the smallest district, you know, DA, county DA you can imagine, and having them prosecute the crime. It's just a very big mismatch between the complexity of crimes and the resources of the institution. So I think more than any of these legal and political issues facing the court, in some respects, I think the actual capacity of the court is something we should be focusing on quite a bit.